of Learned Claimants Council that until a letter of termination of appointment was served on the claimant, any alleged termination by the defendant is not effective. Perhaps what should be borne in mind is that in a contract of employment, a master can terminate the employment of his servant at any time, provided the termination is in accordance with the terms of the contracts of employment, or where the contract does not expressly provide for a required length of notice as the instant case, by giving such length of notice deemed by the courts to be reasonable. In the present case, there is no clause in Exhibit C1 for mode of termination of appointment by the parties. It was not in dispute between the parties that the defendant stopped the salary of the claimant and that the shop was subsequently locked. In the course of the trial, the claimant was recalled to testify, and under cross-examination by Learned Defendants Counsel, she testified as follows, I quote, "The defendant ought to have given me 3 months' notice of termination of my employment. There is nothing in writing. I was only asked to close the office. The notice ought to have expired in December 2012 because payment of my salary stopped in September 2012. End of quote. It is considered pertinent to restate the time-honored cardinal principle of the judicial process that the relief sought by a claimant in an action is fundamental to the fate of that action. Indeed, the relief sought is the bedrock and life wire of an action. Therefore, where the relief sought is uncertain, uncategorical, or is not supported by evidence on record, or does not reflect the course of action, the entire exercise of the proceedings become futile, as there will be nothing for the courts to grant at the end of the day. The court will be compelled to throw out the action. See the cases of Joe Golding Corp. Company Limited versus CDB PLC, Uzoku versus Ezeonu, NECA VBB Manufacturing Company Limited versus ACB Limited, citation supplied. As I earlier stated, Exhibit C1 intended to protest a case has no clause for notice of termination of employment by parties. Evidence on record is that her salary had been stopped in 2012, and further evidence is that the shop office was locked and the claimant could not gain access. There is no scintilla of evidence on when our salary was reviewed as alleged to enable the court to determine the period of notice to be given and to assess damages to be awarded if necessary. The claimant admitted that the office had been locked even when she goes to work. Her claims for unpaid salary, other emoluments, and several allowances are not supported by evidence, and I so hold. In totality, the claimant has failed to prove her entitlement to her claims. The final result, therefore, is that the case of the claimant must and hereby fails in its entirety. It is hereby accordingly dismissed for lacking in merit. Issue 2. Have the defendants discharged the burden of proving their entitlements as claimed? Undoubtedly, and as correctly submitted by Learned Claimants Counsel, a counterclaim is a separate and distinct claim from the main claim. This is so because even if the main claim fails or is withdrawn or struck out, the counterclaim will survive. To put it differently, the same standard of proof required to prove the main claim is also required to prove the counterclaim. See Attorney General of Lagos State versus Attorney General Federation, Ogilioko Memorial Farms Limited, and another versus Nigeria Agricultural Cooperative Bank Limited, citation supplied. The defendants contend that the claimant continued to carry on the BDC business after she was instructed to close the office, and she thereby carried out nefarious activities by defrauding some people. In proof of the claim for the sum of $2,300,000, the defendant tendered in evidence Exhibit D4 of fund transfer form of money transferred to one Bishop Bagobiri. According to the defendants, the said bishop was allegedly defrauded by the claimant, and the first defendant refunded the money to him via Exhibit D4. In our defense, the claimant tendered in evidence Exhibit C2 and C3, the originating processes of case instituted against the claimant by investors of the Bureau the Change in suit number KDH/KD/AC7/2018, and the case instituted by the claimant against the present defendants in suit number KDH KAD/1028/2017. The submission of Lanek Claimants Council is that the defendants made allegation bordering on crime against the claimants, and that this allegation can only be determined by a court of law. Lanek Council argued further that there is no evidence before the court that the said bishop was defrauded by the claimant, and the defendant did not establish that the payments made in Exhibit D4 was as a result of a complaint by the said bishop. I observed that the defendants in their pleadings at paragraph 13 and 14 made the following averments. Paragraph 13, the defendants averred that the first defendant had repeatedly warned the claimants to stop indulging in such referrals activities, but the claimants, who pretended to have heeded the warning of the first defendant, continued with her illegal activities behind the back of the first defendant. Paragraph 14, the first defendant averred that at a point in time, the first defendant, who never knew the extent of the shady deals of the claimants, got to know after the claimants had defrauded a certain late Bishop Bagobiri of Kefanchan, among others. End of quote. These averments will appear to have raised and asserted that the claimants committed fraud in our dealings with the said Bishop Bagobiri. The question I ask here is whether the defendants have effectively raised and successfully proved the elements of fraud in their case. When a party raises an allegation of fraud or other criminal offenses, it is pleading, in its pleading, a rule of law requires that such allegations must be specifically pleaded and supported with particulars. The reason is to enable the party defending the allegation to understand the case he is facing and prepare his defense. See the cases of High Grade Maritime Limited versus First Bank Nigeria Limited, the case of Global Form Work Nigeria Limited versus EA Gorem Limited. Citation supplied. In line with these authorities, Enameka Agu, JSC, in Michael Ifeanyi Ojiba versus Ojiba, 1991, 6th Supreme Court of Nigeria Judgments, 156, reiterated the principle as follows. I quote, one of the most fundamental rules about pleadings of fraud is that pleadings must contain precise but full allegation of facts and circumstances with all necessary particulars, end of quote. There is no doubt that the amended statement of defense of the defendants is bereft of any particulars of the fraud and nefarious activities alleged against the claimant. The particulars, the time, and the place, and other essential things have not been stated. That is why no cogent evidence was led to prove the allegation. It was a wild cat that was thrown, but it fell to the ground without any effect. Having not provided particulars of fraud against the claimant, the defendant has failed to prove their claim for the sum of money that was purportedly refunded to Bishop Bagori, and I so hold. Without further ado, the defendant's counterclaim fails in its entirety, and I so further hold. In the final analysis, the claimant's claim and the defendant's counterclaim lack merit in substance and are hereby accordingly dismissed. Parties shall bear their respective costs.
I know we agree. Thank you.
Thank you. I'll find a means of getting transmitting or getting the judgments available by the end of next week, please. Thank you.
Thank you.
The court shall rise.